I'll be presiding. We have Judge Bryson and Judge Davis. Your cases, are there any preliminary matters that we have on these cases before we start?
No, Your Honors.
Thank you very much, Dan. And are we prepared for the appellant? You may start.
Okay.
Have you reserved your time?
Yes, Your Honor. Can you call it, or can I just...
Yeah, Angela Heisig versus Andrew Heisig.
Good morning, Your Honor. Thank you for that. Welcome. Phil Jacobs for the appellant wife. I would like to reserve 4 minutes for rebuttal. I'd actually like to come back to the law on this case because both briefs cover that part well. It's clear that $130,000 was awarded to wife in the MDA, and it was silent as to gains and losses. That's not in dispute. I would like to have a discussion about who bears the burden in these situations and whose asset is that $130,000 and when. If the law is that assets are to be valued as the date of divorce, then what other factors apply when you can't go directly from a final decree to the distribution of the asset? There has to be this intervening quadro in this financial institution. So when is husband unjustly enriched by having the use of wife's money? There's this idea that because the asset is within the husband's 401k that it's husband's money. Well, it's marital money. It just happens to be invested in husband's 401k. It's not husband's money. All this money was earned during the marriage and then divided equitably in the MDA. Specifically in this case, it's important to note that more than half was awarded to wife as an equitable consideration. Husband got a pension, wife got 60, 65, 70% of this 401k to offset that. Everything else was divided equally. So that's very important to note. That's why there is a specific number and not 50-50. Finally, this idea of economic injustice or economic financial justice, what is fair between these parties and what is equitable. So the facts of this case are very important because there's this idea that, all right, we had a final decree, we had an MDA, and then nothing happened, and then we just presented this quadro with requests for gains and losses 2 or 3 or 4 years later. That's not what happened. That's very important in this case. So if you'll forgive me for leaving out some of the specifics of this, because what I'm trying to get to your attention is kind of what all happened here and when did this burden shift, or when should there be this shared responsibility of this quadro. So the final decree in MDA was entered January 2018. There's a series of post-judgment motions filed for ancillary issues, fraud about how much was disclosed in the 401k, insurance braces, just things that happen between litigants. Those are all resolved in June of 2018. Then husband hires a new lawyer. We go to mediation on parenting issues. We enter this new parenting plan. And for the first time in December of 2018, so 11 months later, this quadro is presented to husband's attorney, notably no gains and losses. So if that quadro gets executed right there, no problem, we move on. So there's a series in the record of these stipulated emails between counsels, paralegals about, hey, we need to file a petition to open up the record and get this quadro entered and blah, blah, blah. Who's going to draft the petition? Is it going to be joined? We got to get this parenting plan entered at the same time. So there's this wrangling going on, not contentious, just something that goes on, but certainly no effort by husband's lawyer to do that at that time. So does the burden shift then? So then we get to August of 2019, and wife's attorney, me, sends a quadro that says, hey, we want gains and losses. We put it in there. Now it's been 19 months. Surely we're entitled to gains and losses now. Okay, we propose that to the court. It gets filed with the Hamilton County Clerk. Husband files an objection into August. Then he files his own 2 months later that says no gains and losses. So the court takes those into consideration, and the trial court enters the husband's proposed order December 2019. Okay, so now 23 months later. Now this is really important, and I'll try to move quickly. Wife's attorney files a motion to alter amend. It's granted. The judge kind of splits the baby and says you get post-judgment interest for the 11 months that you presented this quadro and husband didn't act on it. Okay, we get $10,000. That's January 2020. That order, boom, enters. Really importantly, by February 4th, just a month later, we have a quadro that provides for this $139,000. No problem. We send that to Fidelity or whomever. We get our money. But husband files a motion to alter amend, saying, hey, we got too much post-judgment interest. Well, that gets filed and boom, 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 March of 2020, there's the pandemic, okay? Not really that important in this case, because by April, we get an order from Judge Hedrick that says, all right, we're going to reduce the post-judgment interest to just this 6-month period of time, so we get $2,000 or $3,000. Okay, well then who's supposed to draft the quadro then? And who's supposed to prepare it at that point in time? In the MDA, wife's attorney was supposed to do it. We did it. But now who's supposed to do it? Well, it doesn't get done, and then August of 2020, a gains and losses one gets submitted, signed by both parties, which ultimately was determined to be in error, and I'll come back to that. So, but that quadro doesn't get submitted to the institution, the financial institution. Everybody sits on it. Husband, wife, counsel, nobody does anything to it until spring of 2021. Husband alerts wife, hey, this money's still in my account. Why is it still in my account? So in April, it gets submitted by my office to, I think it's Fidelity, but the financial institution, and boom, the money gets divided. But guess what? $55,000 approximately goes to wife. That's all gains on her $130,000, not on husband's, just on her money. Now, $55,000 is more money than was awarded to husband initially. Okay, so then in earnest, husband's attorney files a motion to set aside. We have a contested hearing, argument only on, and the court sets it aside. And so July 15th, the order that we appealed says no gains and losses, nothing but this $2,000 or $3,000 of post-judgment interest at all. And here we are on appeal.
What period of time did that post-judgment interest cover?
What period of time? It's the time from August of 19 to, I think it's December of 18 to August of 19, that period of time. Originally, it was the whole 11-month period of time, so essentially it was cut in half. I think that's accurate, but basically, husband's attorney argued, hey, you shouldn't get additional time while you were trying to present this gains and losses erroneous quadro. So it was cut by $7,000. All right.
Cut by 7,000 or 7,000?
7. So the post-judgment interest originally was like 9 or 10, and it got cut to 2 or 3. So that's the mark. But the gains ultimately in April of 2021 was $55,000. So the question is, when does the burden shift? And that's what I'd like this court to entertain a discussion on. Is it between husband and wife or shared? Is it December of 18 when our office submitted the quadro without gains and losses? Was it August of 19 when we proposed it to the court? Was it February of 20 when we had a valid quadro signed with that $9,000 or $10,000 of interest added? Was it August of 20 when we had a quadro that was effective? I mean, this is long periods of time. Here we are, 2022. This is all significant. When should there be some shared responsibility between these parties? I know I have time for rebuttal, but I'm going to quickly move to the law of this because I've covered kind of the facts. And many of our cases are from different jurisdictions, so that's noted, and I'll try to catch that as I go through it. But this Florida case, Huffman, whenever there's a fluctuating asset, the court found there should be gains and losses. So if we got an asset that is affected by the market and the agreement is silent to it, it's either no gains or losses or yes gains and losses, then if it's going to be affected by the market, then everybody should enjoy gains or losses. Then there's this Connor case.
Excuse me for interrupting. In
Yes,
the
Your Honor.
Florida opinion that you just referenced, was the award a specific amount or percentage?
Percentage. That one was percentage. So, and I think that is something that is distinguishable in different cases. Okay, are we sharing this burden equally or are we not? And therefore, it should be gains and losses kind of inherently in that. I would suggest in this case, it's more important that we look at gains and losses because my client got $130,000, and so the husband is essentially using her money, quote, her money, to gain, and he's not harmed or affected in any way. And so I'll come back to that if I answered your question.
But how much control does he have over that?
Well, he could have prepared a quadro. He could have not challenged the order that Adopt gave post-judgment interest. I mean, he could have done a lot of different things at different times, and he just chose at every turn to rely on the wife to draft the quadro or to get it before the court or open it up. And so
It's her money, isn't it?
I will acknowledge that as a weakness in our position. You can't get around that maybe she should have done more, but she got a quadro entered in February of 2020, ready to submit it, and husband challenged it. And after that, what can she do but wait for the husband to challenge it, the court to enter an order, et cetera, et cetera. So at that point, it was out of her hands. This Connor case from Pennsylvania, it has this verbiage: to distribute husband's Schwab IRA without regard to the significant value fluctuation that occurred would undermine the legislative intent of effectuating economic justice between the parties. I read that as equities. What's equitable between these parties? Are we really going to allow husband to get $55,000 that he did not earn or is not earned during the marriage? Is that really what's fair between the parties? The Tennessee case has Jordan, which is on page 10 of our brief. Court cannot simply order immediate transfer of funds. The risk of gains and losses should be shared between the parties. So if we're sharing it equally between the parties, then why not? If you don't mind, I'm going to dip into my reserve time for just a second. The Kaiser case, I think it's from Oregon on page 12 of our brief, there was some delay, but if it's not undue delay, if we're litigating other important things, whether it's the post-divorce motions or these kids, then there's no harm to either side, especially if husband gains is coming on wife's money. He should not be enriched by gains on wife's money. And finally, this case out of Missouri, Gardner, there was a delay in entry of a quadro on a pension between 1993 and 1996, and there was no harm to husband found. So to interpret or construe would be essentially to award husband earnings on wife's asset. And that's what I take you back to our original point of, when does the burden shift? Whose asset is this and when? And should the husband be unduly enriched by the amount of money awarded to wife when they contemplated this by agreement? The rest of my
I presume that this is an issue of first impression, since you're referencing cases from other jurisdictions.
We worked hard to find the best cases that present to the court. I commend my adversary for writing an excellent brief that points out the weaknesses to our positions, and I'll let him argue it, but certainly there are other Tennessee cases. But what we found is, in terms of presenting it the best way possible, these were the cases on point as best we could find.
Thank you.
Thank you. Yes, sir.
Good morning, Your Honors. Nate Kennard of the Chattanooga Bar. It's good to be with you this morning. May it please the court. I want to clean up a couple references that my esteemed colleague made in regards to the factual record. There was a suggestion in something he said that husband failed to act in connection with drafts of things that were given to him. Well, there's no factual finding from the trial court, no evidence asserting that the husband has in any way failed to act in response to some obligation that he had, neither he or his counsel. And as he himself acknowledged, the marital dissolution agreement in this case, incorporated into the final decree, said that wife is supposed to prepare the quadro. I'm not sure about where this question of, when does the burden shift? This isn't, a case where we're talking about allocating risk of loss, some sort of complex insurance dispute. I don't know where that comes from. I've seen no case which resolves a question like this one based on, this question of when does the burden shift that Mr. Jacobs has asked. If it did matter, I think we'd have to look at the agreement, which says the wife is supposed to prepare the quadro. In fact, not only is she supposed to prepare the quadro, but to make sure it happens and she can afford paying her counsel to do it, husband, in fact, provided her $500. It's in the marital dissolution agreement. So she really didn't have any excuse for getting it done in a prompt fashion. But it really doesn't matter, who had to do it and when. What really matters is the terms of the agreement itself. That's what we have to focus on. That's what Pruitt versus Pruitt says. We have to have a laser-like focus on the terms of this agreement, because that's what we're enforcing. We're not evaluating whether it was wise to do this agreement in a certain way. We're not evaluating whether it's fair or equitable. What we're evaluating is the best interpretation of the terms used. And the terms used are, I think, pretty difficult to argue against. First, a specific sum is awarded to the wife, $130,000. And if there were any doubt, it's actually down to the penny. It's listed out, $130,000 and no cents. And a term like this, you can help understand just how clear it is by looking to other provisions, including later on at the middle of the page, Appendix 9, Section 5.5, the remaining balance of said 401k shall be the sole property of the husband. If we had any question about $130,000 means $130,000, no more, no less, then it's resolved by that sentence, the remaining balance. She gets a specific number. What he gets, it could change. It could be $0, it could be $5, it could be $500,000. I'd love that, but what if the market had turned down, right? The market is now in a changing condition, and he bears a lot of risk by having agreed to this term, in the same way that she, in the words of a Wisconsin court, negotiated the comfort and security of a fixed sum.
Question for you, hypothetically, if the market had turned down, and let's say the balance of the account was less than $130,000, I wonder if your position would be that he can't pay the $130,000 because it is an impossibility, or is he still obligated to pay the $130,000 because that's the sum that he agreed to and therefore bore the risk and loss?
So I think I think it would require a predicate question of whether, under Tennessee law, the award of a particular asset is very much focused on that asset. Is this an award of $130,000 in cash, right? And I think, no, I think it's an award of $130,000 from this account. So I think the probable answer is actually she would get less than, she would get whatever the amount is. If there's $129,999, she would get that and he'd get zero. Now, there are actually authorities cutting the other way on that point. There was, or at least some judges have argued that. They've said that in a circumstance like this, we have an impossible award, say if it were applied to this case, $130,000, but the market has dropped below that sum. At least some judges have said, no, you need to make up the extra from your other assets. So I don't think I can say with certainty what would happen, and it is a hypothetical. My tentative answer in the first instance would be she's actually out of luck in that circumstance. She gets all of it, he comes away with nothing from it, but she gets less than 130. But there are judges that have said the contrary.
So what about this 130,000? That exactly was what's used to make the additional money.
I think that is sort of that's probably the best argument that wife has is, well, this is my money, and that my money made these gains and benefits. And there is I think the Missouri case that opposing counsel cited supports that position. Now, granted, it wasn't on point with this. It involved just a percentage. It didn't involve a specific sum. But let's say it had. Let's say we were facing that case, on all fours. I don't think it holds water. The Missouri case didn't cite a single case supporting that proposition. Not one. Not one. And Jordan versus Jordan from this court, in an opinion by Judge Susano, I think completely destroys it. He said, look, a division of marital property involving an asset like this is literally not even complete. It's not even done until the quadro has been, in fact, qualified by the plan administrator. Judge Susano said there is no enforceable right until it's been qualified by the plan administrator. And occasionally we get into these really interesting questions of like, what does it mean to own something? one of these kinds of basic questions that I think law students noodle on a lot, and I have to be honest, this is the first time in my practicing career that I've ever actually had to answer that question. What does it mean to own something? And the bundle of sticks is the classic metaphor for a good reason. You can have, you might have this stick, you might have another stick, somebody might have a life estate and property, but, that right ends, so there's no right to testamentary disposition. And so what sticks does wife have before the plan is qualified, the plan administrator? I think Jordan versus Jordan says none. None. Her bundle is empty. Now, of course, she can get that order qualified, get it sent, and make sure she has an order that would satisfy the requirements and get it to a plan administrator. And at that point, there you go. It's hers. All of a sudden, it goes, once it's divided off, it belongs to her. She has, you might say, a fee simple interest in it. But until that point, she has literally nothing, right? I suppose she could do something the equivalent of a quitclaim deed to it, and try and promise an interest to somebody else, but it wouldn't be any better than me saying I sell to you my 100% interest in the Tennessee Titans. To be clear, I don't have any interest in the Tennessee Titans, and it wouldn't be worth anything, right? That's why it's so important that the marital dissolution agreement said, wife, it's on you to get this thing done. It's on you. And it strongly incentivizes her to move quickly in a rising market. And so that's why in our brief we argue, and I think with full confidence, that there's no inequity that results here. The law is rife with statements like, you can't sleep on your rights, right? I mean, it was 27 months between the divorce decree when it was finally submitted. It was 11 months before a draft was ever sent to husband's counsel. And at that point, the case was actually closed, and the case would have to be reopened. A filing would have to be made, which husband's counsel said, look, nothing's going to happen unless you file a motion to reopen the case. And eventually that happened, like 8 or 9 months later. And then there was the problem that the document which was submitted, and if you look in the record, it was submitted ex parte to the trial court. The document that was submitted, unlike the previous versions, said wife gets benefits on the account, the gains that accrued on this account. And so if there's any suggestion that husband slowed anything down, it's because a quadro was submitted that said something that wasn't justified by the marital dissolution agreement. I don't think that any sort of injustice results from trying to get it right. We're trying to interpret and enforce the judgment that was submitted. A couple comments. Mr. Jacobs referenced this case from Pennsylvania, Connor. We distinguished that case in our brief. That was a case in which it's a question in the first instance of a direct appeal from a division of marital property, what valuation date to set. It's irrelevant here. At that time, you're asking, what is the right approach to take? What is a fair division of assets? The fair division of assets isn't on the table anymore. That is final and non-appealable. Mr. Jacobs also referenced the case of Jordan, which I've brought up as well, and he suggested that it addresses this question of allocation of risk. I think that's what I heard. My understanding is Jordan versus Jordan doesn't say anything about that. I think he may have been referencing another case, but I'm not sure which one, but I wanted to clarify that. Judge McClarty, you asked what was that date range that the interest which the trial court awarded, what date range did that account to? And appendix page 36 indicates that the court was calculating interest between August 28th, 2019 to December 13, 2019. And those corresponds to the date when when wife first submitted a proposed quadro, and December 13th, 2019, I believe, was the date that the court entered the proposed quadro, which husband submitted. Husband submitted a competing one after saw that the other one had been submitted provided benefits on those gains, and thought there was an issue with that. I think this case presents a good opportunity for this court both to resolve the incident case, but also provide a little bit of clarity for litigants all across Tennessee. Preparing a quadro is difficult and complicated. Trying to identify, the risks of not saying something in a quadro, or saying something, or saying the wrong thing, I think that can be challenging. I think the cases that we cite in our brief show that even subtle changes can have significant differences. We identified 2 states in which you have a fact pattern just like ours, and a fact pattern which is very slightly different. The only difference is a percentage award instead of a specific sum. In Indiana and Alabama, in those states, the providing a specific sum means that's just what you get, the specific sum, and not the percentage award, which also provides gains or the risk of loss. And I think this case provides a good opportunity to look to those courts and say that makes sense here. Mapoi, which we cited, is a Tennessee unreported case involving an award of a percentage. And the court said, look, if you're providing a percentage, then the risk of loss and also the potential benefit gets shared between the parties. But if you want to just award a specific sum, then that's what you need to say. If one party doesn't want the other one to share in the benefits or the risks that associated with market gains, then you need to provide a specific sum in your agreement. That's what the parties did here, and that resolves this case. Unless the court has any further questions.
I hear none.
Thank you.
Yeah, the issue of risk of loss or shifting the burden is just to highlight the equitable arguments to this. And I agree with counsel that I think it would be helpful, not only obviously you have to resolve this case, but you got to, present clearer law on how this is to be handled in the future. Are we going to say the agreement's silent on gains and losses are inherently shared equally? Do you have to say no gains and losses or yes to gains and losses? If you don't say either one, then what do we do? And is it just an equitable argument? And in this case, would it be unequitable to award husband such a gain on wife's asset? But I do think it's lost when you don't go back to inherent divorce law that we understand as fundamental in the state, that assets are valued date of divorce, and then whose asset is it, and then all the wrangling that goes on to get the document affected. And as a practitioner in this state who submits, I won't say 100 quadros a year, but I'll say dozens of quadros a year, it's a pain to do it, and it gets rejected because some third-party entity is in control, not the court. I'd want to get kicked back because the court wrote on it just the other day. So, I mean, the court's not in control, the litigants aren't in control, these financial institutions are in control, so who's going to bear the risk of this loss one way or the other? And I agree fundamentally. There's no one I respect more than Mr. North about him. I don't think he intentionally delayed anything, but when you're looking at emails that he submitted to the record, the judge, the court, trial court approved his version of the statement of the evidence in this case, and he submitted these emails that are rife with, Mr. Jacobs keeps sending us this quadro. I'm paraphrasing. We can't submit it to the court without an agreed order because Jacobs has not filed the petition. Well, why at that point, we got to submit a quadro that he's not signed off on. We can't submit it to the court. So why is my client fully responsible at that point while we're discussing a parenting plan? In August of 2019, there's an email that says, here's the parenting plan from their mediation agreement last fall that we're following. We need to get this entered, and we need to get this quadro entered. And something that hasn't come up, and it's just a sticky wicket, I referenced it earlier. All right, so if Judge Hedrick says you're going to get post-judgment interest now, so you're entitled to something, and I presented quadro to Mr. North that has gains and losses in it, and he approves it, and he said in error, and then again, same one was in August, had the same language, he said in error, and ultimately the trial court said in error. But at what point, if we're giving post-judgment interest and we know it's her money, Does it ever change that she's now entitled to gains and losses? Are we always stuck with this silent language in the MDA, or did this get fundamentally changed when we had this finding by the trial court that there was some delay by the husband's attorney, and that's why there was originally $9,000, $10,000 of interest, and then reduced to $2,000 or $3,000. But if there's some delay by husband's attorney, does the conversation not change? Is it not in the hands of the court to now change and have the discretion to say, yes, now that we've got this judgment increased to $132,000, we're going to allow gains and losses, and that would have had a significant impact, $55,000 worth of impact. So I agree with counsel that it would be beneficial for, he used the word opportunity, I would agree, to clarify this matter moving forward. Really thank you for your time, and I'm sorry I didn't leave you any time for more questions. If you have any, our other case got bumped, so we're here.
All right, Danny, please.
All right, thank you, Your Honors.
We want to thank both the attorneys for your presentation. Your case has now been submitted to this court, and you should receive an opinion and judgment from us within a reasonable period of time.
Thank you, Your
Thank you very much. Madam Clerk, will you kindly recess the court?